Hi, I'm attorney Keith Johnson, and welcome back into the Lawyer's Lounge. On this episode, we're going to talk about that famed first court appearance. This is where a lot of times the story picks up in Hollywood, with the dramatic scene of the lawyer strolling into the courthouse, the prosecutor having their file ready, the judge scowling at the defendant. But well before we get to that point, there's a whole process behind the scenes. And that's what my job is, to take you behind the bar so that you have an inside look at the criminal justice system. The case doesn't just begin in a courtroom. There are things that happen that nobody knows about. The client has emotions. The family is worried. And the state is putting together their case. As a defense attorney, a lot of times people think we have all the answers. But we have to piece everything together, and we're flying blind. A lot of times, the first opportunity that you hear the other side is at that first bond hearing. So stay tuned. Lock in on this episode of the Lawyer's Lounge. So on our first two episodes of Behind the Bar, we first talked about how a crime originates and how crimes can be spontaneous or they could be more deliberate in nature, where there's an investigation into criminal organizations or activities of that sort. Then we went to when your freedom is restricted and what it really means to be arrested and what our founding fathers wanted our rights to be and why that was so important when the government comes knocking at your door telling you you're under arrest. And everything that goes into that jail scene, the smells, the inmates, the process. So let's fast forward. The consultation, that's where I come into play. That's where the defense attorney comes in. We don't know what happened before we're contacted most times. And I make it a habit of mine not to really watch the local news too intently. I used to do it all the time because I wanted to know maybe that was a case that was going to walk into my door. But I found myself being a little jaded, having a bit of a narrative on my own. And I try to discourage people from having the narratives because you are presumed to be innocent in our system. And so I like for the first opportunity that I hear about a case to be when somebody calls my office. A lot of times, especially my more serious cases, the client or the potential client is what we call them, is in jail at the time that I am contacted. So we start with getting the information from a loved one, a family member, someone close who can tell me a little bit about what's going on. I don't get the full story at first. And so we have to make a determination as defense attorneys, is this a case we want to get involved in? The information is most times incomplete. And you have to balance the business aspect of law and just the practical implications of, is this the kind of case I think that I could do well in? You know, when I first started out, as I've mentioned before, I was taking traffic tickets. If you had a traffic offense and you paid me an amount of money, I was going to do your case and try to get your points reduced and all those good things. And so now I don't do those anymore, not because I'm too good to do those, but my focus and my calling has shifted to more serious cases, the murder cases, the robbery cases, the federal cases. And so with those, you become involved in a big mess from the very beginning, because keep in mind, no one calls an attorney, especially a defense attorney, when things are good. We step into what we would refer to as emergencies all the time. And so at that first consultation, I'm filling out the client and the client's family. I want to know, can you be realistic? I want to know, are you a good listener? I want to know, how familiar are you with the criminal justice system? Are you a know-it-all? Are you a ChatGPT lawyer? And no offense, I think people should do their own research to a certain extent. But what I'm not going to do is debate with you about something that I've lived my whole professional life. And that's what a lot of attorneys draw the line at. And so after that first consultation, we determine whether this is a relationship that's worth going forward, because I do use the word relationship intentionally, because I say this is a very important aspect of your life. You don't know me. I don't know you. But I become the most important person to either you, the client, or to your loved one that they have in their life. Think about that. A complete stranger being the most important person in your life automatically. Why? Because there has to be that trust. And so if there's no trust, there cannot be any kind of true attorney-client relationship. And then after we come to an agreement and I've accepted the case, I want to know who's the judge, where's the jurisdiction. Obviously, I know what the crime is. I schedule a client visit. It's important to meet with the client very soon after you're hired on a case, because we are the umbrella when it's raining outside. You want to calm the client down. You want to make sure that the family understands that you mean business, because now you've been retained on a case. That's a fancy word for being paid. So once you get paid on a case, you want to show good business. You want to go and do something, provide some action, even if you know that you can't get the person out of jail or out of custody immediately. And at that jail visit, I go to a place that I'm very familiar, because I go to the jails a lot. As a criminal defense attorney, that's our extended office. So if you don't want to go into the jails, that's like a doctor that doesn't want to go into the hospitals, but you want to be a surgeon. It just doesn't work that way. It's not as fancy as you might see on TV when you're walking into that courthouse in a fancy suit. You got to go down in the trenches. And let me tell you, there's a distinct vibe when you walk into that jail. You know, I've been to dozens of jails in my career, and they all have a similarity. They're usually pretty dimly lit. They usually have staff that can be a little short. And I understand they deal with some incredible stress and people who are upset, because once again, nobody's calling the jail to say, hey, happy birthday, right? So it's always a very intense environment. Luckily, I've been able to get to know some of the staff. So the universal language is respect. I try to treat the bailiffs at the courthouse with respect. I try to treat the jailers with respect. But when you go to that jail, you know who you're there to see, and you go in the back. And I know my way around the back. A good criminal defense attorney will feel comfortable in that space. And that's the first opportunity for the client to really know you or get a chance to see what your plan is. And I'm eyeing to see if the client is going to be receptive to my help. It's become easier now as I've gotten a little further in my career and I've had some good moments in the courtroom. But at first, let me tell you, it was not like that. A lot of times I felt like during the consultation, I was selling my skills, pitching them on hiring me. And that can be a little frustrating, especially when you're asked that $1 million question, well, why should I hire you over fill in the blank? You know, and my thing was, I'm not going to sell my services and talk down on another lawyer to get your business. That's just not how I'm built. That's just not what I believe in. This is what I can do. I was a former prosecutor, blah, 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 blah. But at a certain point in time, you don't have to do that anymore. So when you walk into the jail as a private attorney, sometimes you get a little bit more respect. And that's no disrespect to the public defenders, but it just seems like human nature. People can get the same service for free, but if they have to pay for it, they value it a little more. So I walk in there knowing that this person has selected me to stand beside them during the toughest part of their life. But at that first initial meeting, you can tell if a person's been in the system for a few, years, or if this is their first time. The anxiety level is completely different. And I know when somebody is kind of withholding information from me. And I get it. I'm not here to judge. Remember, we're going behind the scenes. I want to tell it from the client perspective. You got a person that's walking in there that you've never met before at one of the most vulnerable stressful times in your life, and they're asking you to tell them what happened. Well, we all know that we can tell stories that are outside of the story. We do that in real life. We do that as children. So when you have someone who you don't know at all asking you, tell me what happened, like I do, that can be a little bit intimidating. But I always tell clients I have one rule and one rule only. That's to tell me the truth. Do not lie to me, because if you lie to me and I'm surprised in the courtroom, then that might mean that you don't get the best outcome that you could have gotten. And I don't like to be surprised in court. So once we get past all the biographical information and things that I would tell a prosecutor or a judge about my client, the good things, I want to know the worst thing about this situation. Tell me the bad thing. Tell me what happened. I don't want to hear your side. I want to know, what do you believe is the weakest part of your defense, so that I can prepare from the very beginning how they're going to hit us, because they're going to hit us in the spot that they believe is the weakest. We have to defend that first. No different than if you're boxing. You have to know what the strategy is of the opponent to try to defend yourself. And so a lot of times clients will be honest at this point in my career, but that was not always the case. And so as you do it for quite some time, I've had clients just tell me outright fabrications, just lies, okay? And I confront it. We're not here to waste time. Your family has paid me some good money to come here to defend you. If you don't trust me enough to tell me the truth, then maybe you should go with another attorney. And I don't mean that with any disrespect, because let me fill you in on what the bar rules are, because this is important to really know what a lawyer's obligations are. So let's say that I am hired on a case. Obviously, I cannot talk about what my client and I discuss confidentially. That's easy. Everybody knows that, attorney-client privilege. But even during that consultation, if I'm not hired, if they say your price is too high or it's just not a good fit, the information that I am told during that consultation is off limits. It cannot be used. I cannot talk about it, even after the case is over with, even after the client passes away. So that's the level of confidentiality that our bar rules and our laws have determined as appropriate. Literally the secret keeper. So at the consultation, at the first client meeting, that sets the stage for the entire relationship. Think about it like this. No relationship that's not built on trust will last. So there has to be a trust. And the client has to trust that when they tell me something that might be bad behavior, that might be morally wrong, that I'm not going to judge them and not give my best effort because of what they told me. And so that's why in private practice, you can pick and choose the kind of cases that you become involved in. That's why I have so much respect for the public defender system, because they can't pick and choose what cases they get involved in. It gets put on their desk like it did similarly when I was a prosecutor, and you got to take it and run with it. But in private practice, I can say, you know what? I don't want to do that child sex crime. I don't want to do that. I don't feel good about that. But you deserve an advocate that's going to go and fight for you in court. But it might not be my cup of tea at this point in my life. And so when you have a relationship with the client, no matter what the outcome of the case is, there can be trust involved. I've had clients who we didn't win the case, and they write me from prison thanking me for my efforts. Luckily, those are few and far between, but it just shows that if people know that you're going to fight for them, then they can accept the outcome of the case either way. So at the time that I meet with the client, I don't have the information on the case. I don't have the discovery, which we'll talk about in the next episode, which involves the police report, the body cameras, what in pop culture we would call the evidence. So a lot of times you're flying blind. And the first opportunity that you have to really hear the information is at the bond hearing. Now, the bond hearing is a whole thing. As a defense attorney, I would say that's the first big test because until the prosecution speaks, I don't even know what the battlefield is. Once again, my client tells me their version, but they're not attorneys. They might not know all the technicalities and all the things that are going into their prosecution. And the bond hearing is an opportunity for you to show to the family that you know what you're doing. They're all there. Everybody is anticipating their loved one coming home. And in different jurisdictions, they do bond hearings quite differently. In my more rural jurisdictions, sometimes you have to be there all day. They might have a divorce hearing. They might have some probate matters. And you're sitting around looking like, are you serious? This thing said 10 o'clock. It's 1. And you hadn't even gotten to my case. I stopped taking cases in those jurisdictions once I learned my lesson the hard way. Because in some of those rural places, they want to show you that you're an out-of-town lawyer. But different jurisdictions do things differently. In some jurisdictions, they actually call witnesses, which I believe they should, at the bond hearing to swear under oath what they are saying to the court. In many jurisdictions, though, the prosecutor is allowed to just read the police report or the investigative report that I have not seen yet, by the way. It's news to me. So a lot of times I have maybe 60 seconds to think of my response. Do you want to talk about being in the hot seat? That's what being in the hot seat is. I mean, I didn't know there was dash camera video. I didn't know that there was fingerprints. I didn't know that they had pulled my client's phone records. Surprise. And that's what happens from time to time. So in jurisdictions where it's familiar, where we go all the time, you kind of know how things are going to go. You're familiar with the judge. We like familiar judges. We like to know what the judge is inclined to do. We like to know the judge's position on certain crimes. Why? Because I need to know what my presentation needs to be and what are the important parts about this case that I can use to show the judge that my client should come home, that he should fight this case from the outside, like we say. He shouldn't sit in that cage for 1 to 2 years while his case makes its way through the criminal justice system. So when you have judges who are familiar with you and you're familiar with them, there's a level of mutual respect and goodwill that can assist the client. But in those situations where you're walking into a jurisdiction where, I'll be honest with you, nobody knows you and they don't care, you have to really walk in landmines. And what I mean is, you don't want to come and appear like you are too aggressive, too fancy, coming to show these people how to do it. No. You want to lead with humility. And then that brings us to the prosecutor. So not only do you have to fill out which judge is going to hear the case, but which prosecutor is going to have the case. And I'll be honest with you. I used to be a prosecutor, so I know what it's like. I know that it's hard, and God bless them. They have hard jobs, and they have important jobs, and they are tasked with discretion and using that state authority that they have humbly, but also sometimes aggressively if needed. That's just how it works. But there are some who are better than others, like everything else. There are some who are more aggressive than others. But the new prosecutors, the young prosecutors, sometimes tend to be more aggressive. And I get it. They're just coming out of law school. You don't know what you don't know from the standpoint of what's the really major serious case and what's just my first felony case. What's a case where somebody needs to really sit in jail for a long time? Or what's the case where somebody needs help and rehabilitation? That's why mentorship is so important, even with young lawyers. And so when I'm dealing with a young prosecutor, I'm always very, very soft-spoken. What I don't want to do is give them the impression that I'm trying to, like we say, big boy them and come in there like, do you know who I am? This is what's going to happen, and this is how it's going to be. And I was doing this when you was in high school. And at this point in my career, that's true. That's crazy. Weeda, that's crazy. But from the standpoint of what we're doing in that courtroom, you're a licensed attorney, I'm a licensed attorney. And I remember hating when those old heads would do that to me almost 20 years ago. Because I was like, well, I got my law degree now, sir. How can I help you? But when you're measuring up a young prosecutor, you want to make sure that you're leading with kindness. Whether they return it or not, that's on them. But they've heard about you. They know what they're walking into, and they're ready to try to prove themselves. And I respect that. I respect the craft of the practice of law. But I love me a seasoned prosecutor. A seasoned prosecutor is one that may have a little bit of gray in their temples. They might have had some war wounds and some battles. So they know, as they say, when to hold them and when to fold them. They can really talk to you directly about a case and really cut through a lot of the fluff. Because when I walk into the courtroom, I'm walking right over to the prosecutor, to their table. I'm shaking their hand, and I'm saying, I'm here on fill in the blank. I want to know what their position is on bond, because that sets the whole stage. I can let the family know they're opposing bond. And on some cases, the armed robberies, the murders, the sex cases, we know the prosecutor's going to oppose bond because there's a victim in the courtroom and a victim that can be heard. And it's a political office. I get that. I just want to know what I'm dealing with so I can know how to proceed. How aggressive do I need to be at this court hearing? And so when I know which way they're going to go, I can relay that to my client if there's enough time to speak to the client before the hearing. And you have to keep in mind at these bond hearings, it is a packed courtroom. There are different kind of cases that are on the docket. So you may not always know exactly when you're going to go. The client, or as the court system would refer to as the defendant, has an opportunity to ask for bond. Bond is not automatic. The judge has to make that decision. And so I like to have my client's family there for a few reasons. If the judge sees that somebody loves your client and cares about them, they're more likely, more inclined to let them go back into the community with some conditions in place while the case is pending through the court system. The more tougher cases are when there's nobody speaking up to say, hey, he can come live with me, or hey, I know him to be a good person. I employ him. He's a good dad, whatever the case may be. Those are the more difficult cases because now you don't have that visual evidence that this person is a part of a larger community. And the second reason I want family there is because I want them to see exactly what's going on. I believe in transparency. I believe that you should know what the judge thought about your loved one. I believe you should know what the alleged victim said about what happened in the case. I believe you need to know what I'm walking into every time I pick up the phone and call the district attorney's office, because there can be a misconception about what the process really is. Because I understand that little Ty is a good boy. I know he is with his mom and his grandmama. I know he probably is with his cousins. But little Ty is accused of some real serious things. And so we need to understand that your perception of your loved one may not be what the DA's perception of the loved one is. And so having everybody there just puts it all on the table. This is what we're up against, and this is the situation that I am here to defend. And then at a certain point in time, you find out exactly what's going on. I've been at a disadvantage, and so have a lot of defense attorneys throughout this country, because our clients for the last 5 or 6 years have not been in the courtroom with us because of COVID. When I first started, the client was always right beside me. And I think it might be human nature or psychology. It's harder to tell a person no when they're in front of you. It's more difficult. Not that judges can't, because they make a living out of doing that, okay? But it is more difficult than when they're on a TV screen. Because see, when they're in the courtroom with you, if the prosecutor says that it was a gray car, but you remember from your notes it was a red car that they saw pulling from the scene, you can whisper, hey, wasn't that a gray car? A red car? On a TV screen, there is no privacy. There is none of that. And so those little conversations, those little notes that you can pass along to each other to further communicate, can't do that. But that was a price that we had to pay because of the pandemic. But it went on for a little bit longer than I would have liked for it to go on. I can report now in Augusta, Richmond County that defendants, for the most part, are brought over to the courtroom, and I applaud that. I know it's manpower, man hours, but there's something to be said about being in a room and confronting your accusers. That's what our Constitution really embodies. And so when you have the client in the hearing with you, understand that they can't talk. So I talk to my clients about a poker face. It is so important to have a poker face when you are a criminal defendant, but it's the hardest thing in the world to do. I'll be honest. I've had people accuse me of things in my life, and you want to explain. You want to tell your side. We all been accused of things. You want to advocate for yourself. That's human nature. But in a legal sense, you can't be huffing and puffing. You can't be rolling your eyes when the prosecutor says something. And it's very difficult to do, but it's one of the things that I try to instruct my clients, that we're going to be cool, calm, and collected, even if they are lying through their teeth. You let me be the one to call everything to the forefront. Because in a bond hearing, we're going to hear unexpected facts. I try to prepare my client for that. You're going to hear things that may make you believe, no, this can't be true. Or you may hear things that you knew. How did they find that out? I've been there too now. All right. I'm not going to paint no rose color, picture. Like, I don't represent people who can be bad boys sometimes too, because that's part of it. And I'm like, man, you had your SIM card in your phone. Man, I can't believe you did that. Now, you done been in jail so many times. You did what? You had all this cash right next to the drugs that you were selling? Not that I advocate for those things, but those are the facts that come out at bond hearings. And the client is looking like, oh my goodness. But most importantly, on these cases and these bond hearings, in that highly charged environments, when you have a victim speaking to the judge, asking the judge not to let your client out on bond. Man, that's tough. That's tough. Because the judge in the state of Georgia are elected officials. In the state of South Carolina, they're elected by the legislature. So you want to talk about inside baseball and politics. South Carolina is an example of that, how they elect judges to 6-year terms, but you can only be elected by the state Senate. Well, who knows that many state senators? And some of them can practice law. But I digress. The judge still has to make a determination. Do you get out or not? I got this mother crying. I had one 2 weeks ago. The mother is crying. She's lost both of her kids. Both of them. 16 and 21. My client is accused of driving a vehicle. The vehicle got stopped. My client's defense, and it's going to be common knowledge, so it's not anything that's confidential. I said it in court because I had to say it. Both of the boys in the back have firearms. One had a warrant. That is going to be proven. And when the officer went back to his vehicle, after initially coming up to my client's vehicle, one of the boys in the back said, if he pulls me out of the vehicle, I'm shooting. I'm not going back to jail. My client thought this to be a real threat. The officer comes back. He pulls off. He drives for less than a mile, runs right through an intersection, crashes into someone else. Both of the boys in the car, one was in the passenger seat, one was in the back seat, die. Both of them. 2 guns are found in the car. There's another young lady in the car who does not die. My client does not die. He's charged with the deaths of his 2 passengers. I had to hear that mother wailing, and man, my heart went out to her. I'm a dad, first and foremost. And the judge had to make a decision. He didn't grant my client bond, but I think we have a really good defense. My client was under duress, and the evidence in the case shows that, hey, there were guns in the car. His story is not implausible. Does it mean that he gets off scot-free? I don't know. But those are the determinations every day in courtrooms that judges have to make within 20 minutes. Do I let him out or not? My argument was this was an isolated incident, Your Honor. We don't have a crime spree. We don't have a young man with a prior criminal record. He's 18 years old. We have somebody that was involved in an isolated traffic accident. As horrible as it was, he's not a greater threat to the community. Let him fight this case, meet with his lawyer, not through a jail cell, but face to face and be presumed to be innocent. The judge kept him in jail. That was my most recent example of a highly emotionally charged bond hearing where the victim gets a chance to speak. And you may say, well, did your client get a chance to speak? No, because we have to wait for trial. Why? Because if he says something, it can be used against him. So it's a lot of chess. It's a lot of strategy. And he has to trust me. His family has to trust me because they wanted to talk about the young man that he is and how they miss him. But it wasn't an appropriate time to go back and forth in front of the court. I wanted to give him every opportunity to get bond. So that was my strategy. It didn't work this time. It works a lot, but it didn't work this time because nobody bats 1,000 in this job. And so when a client does not get bond, you really don't have the leverage on your side. See, we want to get bond so that the case can get old. I'll be honest, in the criminal justice system, and if a case gets old, we kind of have more of an advantage. We can wait it out. Your client is going about their business, living life, showing the court that they can abide by bond conditions, and that can paint a story down the road when it's time to determine, does this person need to go to jail? Well, judge, you let him out. He's working. He's going to school. He's taking care of his daughter. He's doing those things. I know what he is accused of was bad, but look at where he is now. It helps you tell that story versus they walk into the courtroom in shackles, looking like a prisoner. It's easier to keep them in that mind state if you're making that decision. And so that is why getting bond is so incredibly important. And that first court appearance is a real test. And so if the client doesn't get bond, they go back in the back. And I try to meet with the family immediately after, and I try to go see the client very soon after, because now we know it's going to be a fight. It is going to be one where trust is going to be tested. Once again, remember I said that every relationship has to have trust for it to be a good relationship. And so some people don't take accountability that they put themselves in certain positions to be in trouble. Some believe that if they've paid you, it's your job to get them out of trouble. I understand that to a certain extent. It doesn't mean that it's any less frustrating. And so there are times when attorneys are relieved from cases or fired from cases or terminated from cases, or the relationship just doesn't work out after that first bond appearance that doesn't go well because there's a lack of confidence. And if there's a lack of confidence, everything that you do from here on out is going to be scrutinized. So from the defense attorney perspective, we are praying that our client gets bond. Why? Because we want them to be free, but we also want to have a more stress-free environment. And so the judge has to really make a determination on what we refer to as bond factors. And the bond factors across the country can vary a little, but here's the gist of it. Like I said, you're going to know more than the average person, all right? First, is the person a threat to the community if I let them out? So judges will look at your prior criminal history if you have them. And sometimes clients don't have any. And if they don't have any, we got a real good shot to get bond. That's when I see the justice system really, really work from the standpoint of innocent until proven guilty. There are some crimes, there are some allegations that are so serious, even if it's your first one, you may not get bond. Okay? But ultimately, if the person doesn't have a long rap sheet, we have a better chance of getting them home. If they have a long history, they've been to prison, they're on probation, now you're fighting an uphill battle. So first they have to determine, is this person going to be a threat to the community if I let them out? Then they have to determine, is this person going to show back up for court? Are they going to be a flight risk? What were the circumstances around how they got arrested? Did they surrender? Did they turn themselves in? I had somebody call me yesterday. He's wanted. He's going to come into my office today. He's going to retain me in a few hours. I'm going to call my friend at the U.S. Marshal's office. I'm going to let him know that this man has hired me to be his lawyer and that he's going to turn himself in this evening. He had to get his affairs in order. That turns the temperature down on everything. So now he's not over here being a fugitive and the police roll up on him crazy and it just causes a whole scene. So sometimes if your client turns themselves in, it makes it better. I've had cases where the client don't do that. And eventually they are arrested. And when we get to trial, that always comes up. Fortunately, I've been able to win a few cases like that. I guess because I just make the argument like, listen, I can't hide it, so we just gonna talk about it in the opening statement. And I say things like, listen, my client didn't do what I would have wanted him to do, which is go to the police station and say, here I am. I know I didn't do it, but here I am. I say, well, that would be counter to human nature. Most people run at first until they get their thoughts together. And that's what my client did. But if that's the worst thing that he did, then he's still not guilty. You try to spin it, but that's not the optimal thing. So after the judge determines whether you're a threat to the community or a flight risk, the judge has to look and say, is this a case where there are witnesses who could be intimidated? If you have one of those cases where you're representing somebody who's the head of a criminal gang organization or something of that, where they are at the top of the list, what they call the hierarchy, then now the prosecutor usually makes that intimidation argument. That, hey, if they get out, my witnesses are not going to feel safe. They are not going to feel like they can tell the truth and their stories are going to change. And that's not justice, Judge. And that's when I have to say, wait. He's presumed to be innocent. You got his jail calls. Has he made any from the jail? This man knows he's in trouble. You think he would do something foolish like that? So you try. And that's what makes the horse race. You win some, you try not to lose any. But the bond hearing is the judge's determination. And the most frustrating part about the bond hearing for me is that I don't get to cross-examine witnesses. See, that's where I make my money and my bread and butter is asking those cross-examination questions and really seeing if the person saw what they really think they saw. How they gonna do under pressure and under oath when people are watching. Are they gonna squirm in their seat? Are they gonna just go blank and just start agreeing with what I'm saying? I don't know. But at a bond hearing, the prosecutor's just reading off of a police report. And we all know who writes the police reports. Honestly, it's the police. I get it. It's one side of it. And so at the bond hearing, you have to always keep in mind that you don't want to show them too much. You may have something in your back pocket, that big trump card in your back pocket, right? But you can't throw it down. Why? Because you don't want to give them 9 months to prepare for your best argument. That'd be foolish. So you may have to sacrifice a short-term victory, or a short-term loss for a long-term victory. But at the end of the day, it's about strategy. And so another thing that makes bond hearings interesting is that judges act differently when cameras in the courtroom. I've been fortunate enough and blessed enough to have high-profile cases throughout my career, ones that are media noteworthy, ones where the camera is in the courtroom. And when the camera is in the courtroom, the news media has to submit an order to the judge, asking the judge to allow them to be in the courtroom. And if that's approved and I see it from the time I walk into the courthouse, I know, okay, they're here for my case or they're here for a case that's noteworthy. And judges get a little squeamish when they see that camera back there because they don't want to be on the 6 o'clock news. They don't want to be dragged on these online communities about letting somebody dangerous out. But is that really justice? Like, should you really care what the public opinion is going to be at this point in your career? Now, listen, I'm a juvenile court judge. I get it. Right? Like, somebody's going to walk out of that courtroom unhappy most of the time. It's an adversarial system. It's not selling ice cream where everybody's going to be happy with you. You're a judge. That's what you sign up for. But should your decision be based in any part based on what the reaction is going to be from the community or based on how it's going to be perceived on a news clip? I think not. But I also don't live in a world where I'm naive. I know what happens. I know how things work. And so we just try to prepare in line with the rules of the game because I can't change the rules. But I do know that the camera usually cuts against us. It usually is not in our favor. Now, it does help from a branding standpoint because you're seen as having a noteworthy cases. But ultimately, my goal is to try to get my client home, try to get them back to their life, try to get them back to a sense of normalcy. And so the client's perspective is really just, can this person get me out? I've been sitting back here for sometimes months before a bond hearing. And let's just stay right here for 1 second. You are entitled to an initial appearance hearing within 72 hours per our Constitution, excluding weekends. So that's a few days, 3 days. The issue is sometimes at those initial appearance hearings, you're in front of a magistrate judge, a judge who does not have the authority or the ability to grant bond on more serious cases, on the more egregious cases. So now you need to get a lawyer in order to have a proper bond hearing where the judge will have the authority to possibly let you out. And sometimes that takes some time. Is that justice? See, what I've learned is that there are varying degrees of truth. There are varying degrees of justice. And when you have a justice system that's full of people, it's going to be imperfect. I still believe that our justice system is the best in the world. I know there will be people who roll their eyes. But if we really break it down, comparatively speaking, I still believe you have a shot in this country. Doesn't mean you have a 100% shot in every community, but you have a shot. And it's up to us to tell the story, to shine a light on what's going on in our justice system. And so when we talk about the bond hearing, that's the hard way to enter a case. I mean, that's the headache part. That's what gives me these gray hairs in my temples, to be honest with you. Going into the test, not even knowing what you're going to be asked. Because keep in mind, I'm hearing for the first time what the facts of the case are at the bond hearing. And I have to respond in an artful, forceful way for the court, for my client's sake, and for his family's sake. But then there's another less stressful way to enter a case. We like these when the client is already out on bond. See, there are some offenses where it's relatively minor. Think about your theft cases, your DUI cases, some of the lower level drug cases where you don't have to see a judge in order for bond to be set. And so at that point, if you are hired, you're usually talking to the client directly. There's no miscommunications. There's no translations. Everything is directly with the client. And you don't have that stress of that first initial bond hearing because they're already out on bond. Your first court appearance may be the arraignment, where you enter a not guilty plea. And that is a fancy word, but it's just what I said. It's a hearing where you're summoned to court And now we have to decide, are you going to plead guilty or are you going to plead not guilty? In most jurisdictions, they don't even allow you to plead not guilty without counsel, or they go through a long list of what your rights are. Because even if you are guilty, it has to be proven. That's our court system. And so as a lawyer, I can't recommend that my client enter a guilty plea at the first appearance. I don't even know what the case is about. It might be a technicality. So that's the easier way to enter a case. It's very administrative in nature, and it goes by fairly quickly. It's called an arraignment calendar. But most of the time, you don't make your reputation by being on the arraignment calendar. You make your reputation by getting people out on bond who shouldn't be out on bond. And so at this point in time, we've gotten to the point where the case has officially began. It's gone from theory to reality. We know what we're up against, and now we have a posture of either I got this person out or I got to keep working until I get them out. It sets the stage for the whole entire process, the real process, where now we start exchanging information, where now we start looking to see what witnesses really said. And now we can hit them with our own information at the appropriate time, because a lot of this is strategy. It's about finding the right place where their case is soft and squeezing. That case always has a hole in it, even the best cases. So I hope that this series is impactful. I hope that you are learning something from it. I hope that it's taking you beyond the Hollywood scripts, which are great, by the way. I love them. I don't necessarily watch a lot of it because it feels like I'm at work. But everybody that I know loves them. They like to see it. They like to try to figure it out. And to be honest with you, it gives our profession a little bit of glitz and glamour, because a lot of it is a grind. But keep in mind, I want you to learn something from this. I want you to spread this around, because we need to be familiar and comfortable with our rights and know what it means to be Americans, especially in a tumultuous time as we're in now. So, as I always say, and I feel it appropriate to say when we're talking about bond considerations and the disappointment that can come with that, don't look to the past. It's behind you. There is nothing that it can do other than inform you that you made it this far, that what didn't kill you only made you stronger. The future belongs to the good Lord. It's in His hands. It's not your job to worry about what's around the corner. Do not worry about tomorrow, for it will have its own issues. God will take care of you today, in the present, right now. That's where the magic is. Put your focus on what you can control. And if you cannot control it, don't worry about it. Until the next time, salute.